Hey, good afternoon, Dr. Bach. It's a pleasure and honor to be on your show. First time. So my name is Dr. Bharani Padmanabhan, and it's an old ancient Sanskrit name from southern India. It's very long. You don't need to go, through the whole Padmanabhan bit. Just call me Dr. Bharani, which is how everybody calls me.
Okay, so Dr. Bharani, tell us a little bit about what you have in store for us today. What did you find forensically?
So it's a very interesting thing. It's very unusual. I don't think it's ever happened in the history of the Massachusetts court system, which dates, I think, from 1680s, somewhere over there. So what happened was I reported Medicaid fraud to the U.S. Inspector General for Health and Human Services. Then a whole lot of people got bent out of shape. And eventually, one of those people went to Methuen Police Station and lied that I was harassing her. I bought a gun. I sent a suspicious package to her house, hint, hint, a bomb. And, they investigated and thankfully cleared me and said no crime had occurred. But that didn't stop this lady. She went the next day to Lawrence District Court and applied for a harassment prevention order, which is a legal term. All of us lay people call it restraining order, but legally it's a harassment prevention order.
So just to
And
backtrack slightly, uh, you're a medical doctor, you're a neurologist. She's a nurse.
yes, but basically she
How did you
wasn't.
two coincide? Why was she engaged with you at all?
She was the investigator for the state's medical board. And she was the one who coordinated with my former boss at Cambridge Health Alliance to bring a basically what I call a fake prosecution against me after I'd already been exonerated within the hospital by my peers. So it was a very corrupt scene all around, and that's who went and lied to Methuen Police. And then came to court, and we had a hearing, and if I don't know how many of your viewers have ever had the pleasure of attending a restraining order session in court, but the judge says that you have to present evidence for three so-called predicate acts, acts that the law considers so severely harassing that it can be authorized to limit someone's liberties, because to stop someone, to restrain someone, is a violation of the liberties of a person, and you better have a very strong reason to do so. So we were there in court, and the judge said, well, I don't really see three predicate acts. I don't see even one predicate act. And at that point, this lady said, Your Honor, may I approach the bench? And the judge asked, why? And she said, quote, because both of us are high-ranking public safety officials, unquote. And the judge looked at her and said, no. And what was interesting was when I went back to the court to get a copy of that audio, which anybody can do, it's a public record, it was a public hearing. About 150 people were in court that day for their various other cases or just simply passing by. And, that particular sentence was missing, which raised the dander quite a bit. So I went looking to see, why it was missing, how could it be missing? And eventually, a couple of years later, I finally got the money to engage a forensic audio expert. And he said, this clip that the court gave you is so terrible, it's so degraded quality wise, it's impossible to tell one way or the other. So he recommended that I go and get, probably via somebody else, the audio record for that whole morning session. And so I did. I sent in my columns to a newspaper, a free newspaper called the Valley Patriot, and the newspaper, went and got this audio record for the whole morning, and I sent it to the audio expert, and he was able to show within a day or two that the clip that was sent to me had been deliberately degraded in the frequencies of human speech, which is 300 to 900 hertz. Whereas the audio released to the general public, to the newspaper, was actually of high quality. It didn't have those same degradations. And he was also able to show, because I asked him to look for that missing sentence. I said, I was standing just 1 meter away. I heard her say it. The judge heard her say it. It was an open court. not impounded or secret. We need to be able to get that sentence out. And he was able to show that there was a splice in the court audio just where she asked the judge to approach the bench. So now we have forensic expert evidence, scientific evidence that the court spliced the court audio to remove a sentence which her lawyer considered embarrassing. So that's I think stupendous. That's unprecedented in my view. I went looking through the court records to see if anybody else had come up with this circumstance or scientific evidence that the court tampered with an audio recording that it gave to a plaintiff, a litigant, in a civil case, and I couldn't find any. And so I presented this to the Massachusetts Supreme Judicial Court, the highest court in the state, in the form of a petition for certiorari under a law called Chapter 249, Section 4, which requires the court to take note of these things and to correct errors and to issue a learned memorandum answering the question put to it. And what happened was, one day after the case was assigned to a judge of that court, he denied the petition, basically sight and scene, no hearing, no memorandum of decision, no explanation, no nothing. And that I think is just shocking. I mean, that's just not the way it's supposed to be. The law says that the court should take these things seriously and issue a learned memorandum of law.
So,
something that I'm owed.
Do they have any other excuse for this? First of all, just as a matter of query, I don't know the name of the judge that she said this to. That judge and the judge who ruled in this, those are different judges, or those different courts?
Yes, the restraining order session was in district court, and the denial came from a justice on the Massachusetts Supreme Judicial Court bench.
Okay, so is there any way to ask the district court judge? I assume you can't get judges to do affidavits or be on the stand or anything like that. But is it fair to ask a judge go back to that district judge and point out this forensic gap that you were handed, kind of the dog-eared, the dog ate my homework version of the original file? There was a clearer file at hand. You got kind of the leftovers, chopped up meat, whatever. A, B, this piece was clipped out, and does he recall that instance? Is it possible?
Well, it was 7 years ago, so I don't know if he recalls that instance, and I don't know if he wants to recall that instance. But no, I have not yet approached that judge, and that's a good idea, actually. I probably should.
Okay, so why don't I'm going to put up these. I'm going to remove myself, and I'm going to put up the actual kind of screen shots, and you can talk about these.
Sure. So the first one is a spectrogram. There are two spectrographs. The upper one, which looks sort of dark, not much going on, is the spectrograph from the audio clip that was released to me by the court. The second one, the bottom one, is the spectrograph of that exact same time period that was released to the newspaper, to the general public, so to speak. And you can see that the audio clip that was given to the newspaper, meaning the general public, is richer. It has all the frequencies below 800 hertz, as it should, because that's where people are speaking. Whereas the clip that was given to me, which is the above clip, is very degraded, low quality, and the frequencies below 800, which the forensic audio expert explained to me, there was a precipitous drop off below 800 hertz, wherein all the signals below 800 hertz simply went missing, or were of extremely low amplitude and sound. And that made any sort of forensic analysis of what people were saying difficult, because human speech is between 300 and 800 hertz. So what this shows is that the audio that is maintained by the court is actually of a good quality. You can see the bottom strip, whereas the clip that was given just to me has been tampered with. So that's what this comparative spectrograph shows. Then we also have something called a comparative histogram. So what you're seeing here is the control picture. So if there's an edit made, or if there is a difference at any point in time between one audio clip and another audio clip, you will see a wide orange yellowish band at the bottom of the picture. Here you see there was an edit made because the microphone was switched off and switched on during recess. And in both audio clips, there's really no big difference between the two. So the histogram looks about comparable. The overlap is pretty strong. The next histogram is where things get interesting. Even people with no real background in forensic audio analysis can see that there's a significant difference between the control histogram and this one. This one is of that exact point at which the lady asked the judge, "May I honor, Your Honor, may I approach the bench?" And he asked why, and she said, "Because we are both high-ranking public safety officials." And he said, "No." Well, the question from the judge asking why and the lady's answer, both sentences have been spliced out. And this one here, this histogram indicates the splice. You can see that there is not much of an overlap between the first audio and the second audio being the red and the first audio showing the yellow spread there. So this histogram at that particular point in time indicates an edit, meaning the audio record has been edited at that location. And this is not something that you would expect to see in a courtroom audio record. You really shouldn't be seeing this sort of stuff. So I filed this with the petition, a sworn affidavit from this forensic expert, and the judge just denied the whole thing, threw the whole thing out without explanation, which left me scratching my head. So now I'm in the process of escalating this to the full bench, to all 7 justices of the Massachusetts Supreme Court.
All right. So I'm not going to
hoping that they actually care.
All right. So you got denied at the Massachusetts Supreme Court by a single justice?
Correct.
Are you inclined to name that justice?
Sure, Frank Gaziano.
And is there any animus? Any reason that, I mean, is this judge in particular, has he ever come across your name? I mean,
yes, I mean, yes, I can't name any animus in person in particular, but yes, I have argued in front of all 7 justices twice, and in both times Justice Gaziano was there. He never actually asked me any questions in either case. He was just there.
Okay. Do you want to get into any of that, or you want to kind of keep this?
Well, this case here, where this lady lied to the police about me and I'm suing her for slander, has been in the courts since 2017. And she lost her motion to dismiss. But then one of the judges in the trial court threatened me with sanctions if I kept filing a motion to disqualify the Attorney General from defending this lady in a private civil slander suit, because the Massachusetts Tort Claims Act, Section 10C, specifically bans the Attorney General from defending public servants in slander suits. This is a slander suit. This is a man suing a woman because she defamed him to the police. And so every time I try to get the Attorney General to be thrown off this case, because, you know, the defendant should, by law, be paying for her own lawyer through private funds and not, you know, freeloading off the taxpayer, I've been threatened with sanctions. So one day I took it up to the full bench of the SJC, saying, hey, what's with this sanction business? You know, I'm just stating the law. All I want is the rule of law. And that was when I met Justice Gaziano. It's a video that's actually available on YouTube because the SJC has a YouTube channel, and also through the Suffolk School of Law. And I, you know, Justice Gantz was the Chief Justice at the time, and I sort of jokingly pointed out to him that, you know, it's a no-brainer, which was a joke because I'm a neurologist. I said, it's a no-brainer, Your Honor. The court doesn't really need a neurologist to point out that the law says that the Attorney General should not be defending this lady in a slander suit. And that's when Justice Gaziano sort of stared at me, but he never said anything.
So did they remove the Attorney General from her case?
No, they said that he hasn't been sanctioned yet. So if he gets sanctioned in the future, he can come back. But they did not actually issue any decision, any opinion on Attorney General Healy defending this lady against the law.
And does this Loretta Cook, she still have her job at the board, and what's she up to these days?
Oh, that's very interesting. So she peacefully retired. And then I just found out through the court a week or 10 days ago that she no longer lives in the United States. She sold her house in Methuen for $800,000 plus and moved to Hungary, according to the internet and her LinkedIn page. I never really knew that she had left the country 2 years ago because it's not, my style to keep looking at what Loretta Cook is doing. But yes, I just found out because we're supposed to go to trial on June 24th, and I find that my defendant actually lives outside the country.
So what is that? So first of all, would there be damages? And if she doesn't show, does that mean you win the case? And if you won the case and there were damages, would you be able to collect and so forth?
The Attorney General, who still represents her, 3 lawyers in the AG's office show up to defend her in court and at every hearing. They have assured the court that she will be present on Monday for the trial, and I have no reason to doubt that. The damages, I think, I can't speak for the jury, but I think damages were severe. You really shouldn't be going around lying about people like that.
So
it was
just to
extremely
kind of
harmful.
reiterate, the basic lie was you sent something to everybody on the board. Is that what it was?
I sent a lawsuit complaint and a summons. I had filed it in federal court, which allows you to simply mail a summons and a waiver paper to defendants. The waiver gives them an extra month's time. If they choose to sign the waiver and send it back to me, then they didn't, need a sheriff to serve them in person, which saved everybody a lot of money. It saved me $50 per person, so I just paid $4 for the mailing per person instead of $50 for the sheriff for each person, and that's how it's done in federal court for the most part. So I sent that same summons and complaint to all the defendants, I think 26 in all. And but for this one lady, Miss Cook, nobody else had any complaints. They signed the waiver form and sent it back. Their lawyers contacted me and said, we don't need a sheriff to serve the defendant. We're good to go. But then all of a sudden, this lady went to the police and then to the court, and I get this summons from Lawrence District Court saying you're required to be present on October 31st, 2017 for this restraining order session. And that was a bolt out of the blue. I mean, it was beyond unexpected, especially from a lady who's well versed in legal stuff, right? I mean, this is a person who has sent innumerable subpoenas and summonses to physicians on behalf of the board for years. 18 years she worked at the board. So this was, I just couldn't fathom that, she didn't know what a summons or a complaint was.
So she's an investigator. She's not an attorney. She's not a police person. What is she, a complaint counsel? I mean, what's her role as investigator? She's an RN.
So an investigator is someone who puts the case together under the complaint counsel. So this is the person who signs and sends out subpoenas. And so she's well versed with the legal process in terms of collecting documents, requiring people to show up at complaint committee meetings, and so on. So she doesn't have a law license, obviously, but it's not something that is unfamiliar to her on a daily professional basis.
All right.
I mean, you and I have probably never sent subpoenas out, but she has.
I assume she was upset you found her address and she got something mailed at home when she's probably feels her. I mean, I'm extrapolating here, but let's say she works at this part of the government and all of a sudden you've mailed her something at her house. Now, how did you get her address? Did you get the physical addresses of the other people? Did you mail it to her work or her house? And is that okay I assume you mailed it to her house. Is that okay? And how did you get the address and so forth?
So when you sue someone in his or her individual capacity, personal capacity, you always send it to their usual abode. That's what perfecting service means. So All 26 or so people, they were served at home. And not one of the others had any problem with that, because that's just the way the law says. You send it to their last and usual abode. And her last and usual abode was recorded to the Northern Essex Registry of Deeds. When you own a house, your address is public, period. Okay? If you don't want anyone to know what your home address is, you can't own a house.
Or
You can
you
rent
own it through an LLC or something.
or an LLC or something like the sort. But her name and her husband's name were on the deed as a public document. Everybody has the right to access it. I didn't understand this entire concept that she had tried hard to keep her address secret. You can't do that if you're on the registry of deeds. I mean, that's not secret by any stretch. I mean, lots of people actually sued her. Discover Bank sued her. They served her at home. So she has received subpoenas and complaints, and someone's just at home. So mine wasn't the first in her life at all. So the whole thing was squirrely. I just, I can't give it a legitimate gloss, even if I tried.
So what's the next step? I mean, is there an outlet in the Commonwealth to, to take this? First of all, how would you state the current injury, or I don't want to use the word crime, the peccadillo, whatever, but what's the situation we find ourselves in vis-a-vis the court? We're going to leave Loretta Cook aside because I think we've kind of covered that a little bit. But if you have to frame this for an easy to understand high schooler, what's going on here? What's the travesty, and how does it get corrected, if at all?
The travesty is that the court is not neutral. That's a huge travesty. The court has taken the side of one litigant against another in a civil case, not a criminal case, civil case. And that's just not done. That's beyond the pale, way, way, way beyond the pale. So it violates the 14th Amendment. It violates your right to equal protection under the law. So that's a constitutional violation by the very people who are sworn to uphold the Constitution and dispense justice. So I couldn't, like I said, make this minimize this if I tried, because as I wrote in my brief to the court, this travesty shrieks to the heavens. It really does. You shouldn't be having a court system siding with a litigant in a civil case.
Right.
And breaking the law and tampering with audio evidence and basically treating me as a second-class person. That's what the court did. That
Yes,
my right.
I think worse than second-class person. I think they treated you as an enemy. If you'd just been
yes.
a second-class citizen, you would have gotten maybe the dirtier audio tape. You wouldn't have the thing spliced out.
Without the tampering,
to me like
yes.
Something got fixed. And then the question is, who did that? Was that, I mean, who could be inside the court system with the audio tape, who would cut something out that's prejudicial to the defendant in this case?
Yes.
And so, who's being defended by our current governor, no doubt.
Well, yes, and the current attorney general. So I spoke to her assistant attorney general in 2019. He deposed me under oath. And that's when he found out for the first time that this testimony had even occurred. And he was shocked. He was visibly shocked. I was sitting across the table from him. He was very, very shocked. And I have the transcript for that, which I included in my petition. And I got the audio after he heard about the testimony. It is kind of hard to discount the possibility that my informing the attorney general about her testimony led directly to the tampering.
Right. You pointed out the part that was objectionable, and then that objectionable part disappeared.
Well, I don't know about objectionable, but certainly embarrassing.
So if you just asked for the audio without having pointed out the part that you're upset about, you think it would have been disappeared?
May have flown under the radar. Yes, correct. But I didn't.
So we're going to blame you then.
I didn't have the money earlier on to get the audio, because you do have to pay, and the transcript is very, very expensive. But yes, the attorney general knew about the embarrassing, objectionable testimony before I got the audio, And also the way the court released the audio to me was highly irregular. I've gotten audio in numerous cases. I've been in court, as you know, for 10 years now, and multiple cases, and I've gotten the court audio in at least a dozen cases from different courts, and never have I seen this sort of tap dancing. They denied my audio request 4 times in a row. First, they said, "Well, you applied in the district court. You should apply in the probate and family court." Then when I applied in probate and family court, they said, "No, sorry, you should apply in the district court." Then when I applied in district court, they said, "No, sorry, you should apply in probate and family court." What that basically did was buy them time to tamper the audio. So I think the circumstantial evidence is extremely strong, that they knew what they were doing.
So one kind of question lingering in my mind about her statement to the judge. I mean, I know you kind of circled that and highlighted the statement. What is wrong with her saying that? I mean, what did she say? If you can do the quote once again, and how do you construe that? And what do you think her intent was by saying that? And why do you think people would want to get rid of that statement? Why is that a smoking gun? What's gun-like about that?
Well, it was a smoking gun the minute she said it, which is why I remember it so vividly, so distinctly. I can see and hear her say it right now in my mind's eye.
So what's ballistic about it?
And I can remember the judge's face when she said that. So the question is, why did she ask for a sidebar after the judge had already indicated that she didn't have 3 predicate acts and that she wasn't likely to qualify for a harassment prevention order? And it is, my contention, that the reason she sought a sidebar was to inform the judge that other people in the government want this, that I didn't come here on my own. I was sent here to do this. So you better shape up and do it because the Attorney General wants this. And I think that's why when the Attorney General heard from my testimony that Ms. Cook actually said that out loud in open court, that she and the judge were on the same side, we are both high-ranking public safety officials. It basically meant that, yo, judge, you and I are on the same team here. Shape up, will you? That's how I understood it. I still understand it, which is why I remembered it. Because that was unexpected. I did not expect her to say that. So I think the Attorney General fully understood the same thing that I understood, and that's why they moved heaven and earth to get that testimony spliced out.
All right. Anything else to add?
Well, June 24th, we are supposed to go to trial in Norfolk Superior with the Attorney General defending Loretta Cook in violation of state law and Article 30 of the Massachusetts Constitution. I am in the process of sending in an emergency petition to the full bench of the SJC. And of course, it is not at all a guarantee that they will act before the 24th, but that is my request to them.
Okay, so I'm going to make one addition, probably closing question or comment. I think the whole country has been fairly wrapped up with and wrapped in attention with the raps that the Canton and Massachusetts State Police have been taking in the entrapment, I would suppose, of Karen Reed. And I'm wondering, I know there's a huge, kind of spotlight on that on X.com and elsewhere in the news and so forth about the state acting meretriciously, in its own interest and for possible self-aggrandizement or self-preservation, that is, acting like a cabal against the people, against justice, and fingering somebody, and sacrificing somebody to keep at the altar of their own, jobs, I guess, so they wouldn't get in, however you want to phrase it. Do you have a message to that audience about why they should care about this case? What is it about your case that is analogous and would, I mean, if they have some extra time, because they can't all be working on Karen Reed at the same time, because that's all going to play out. Is there a reason that people should care about your case in general, this particular aspect of it, and or all things Bharani?
Yes. So the minute the government is not neutral, the minute law enforcement authorities are not neutral, all is lost. anybody could be the next victim, not even intended victim, but just, randomly, stochastically, the next victim. And so everybody should care about this, because the next person in this situation could be you.
Fair enough. Okay. Well, thank you so much. And so if people want to find you, can they locate you in any way? I mean, your name's a little bit tricky there, as we mentioned. I can put some aspects up. Are you findable on the internet at all?
Yes, if you spell my name properly, I suppose.
I'll
But
put it. Your name will be on the
yeah, no,
on the name of the show.
I'm on Facebook. I publish columns for the Value Patriot newspaper. I have a Patreon page, even though I haven't really done very much on there. But yes, I am findable for sure.
All righty, lovely. Well, thank you so much. I should really post your name up, but we'll see it as part of the title. Thank you, and have a wonderful day, Dr. Bharani.
Thank you, Dr. Bach.